Welcome to the Real Estate Reserve Podcast, the number one real estate investing podcast in the world. So happy to be with everybody here today.
Yeah, man. I just look forward as we are on top of this ladder as the number one real estate podcast in the world. I'm glad we've ventured out of the United States and now have seeking world domination. But
United States, world, you know it. So we have a little bit different podcast lined up for everybody today. For those of you that heard the underground secret of the private mastermind group that Ian hosted a few weeks ago, he did a lot of kind of behind the scenes interviews and presentations with some local industry experts. And one of them will be sharing with you their presentation here in a second.
yeah, I think we talked about it before, and we shared Jack's presentation. We got really good feedback from it, and everybody's kind of on summer break, and we could sit here and listen to me and Jason talk about how the end of the world's coming and how real estate's the greatest asset and it's going to save us, or we can share the best content. And we've had Michelle on our show before. She did one of our Wednesday night meetups, but she really dove deep in way more in depth than what we did on our last podcast. And I think a lot of the presentation material that she has with this will help you guys understand how to legally raise capital, whether you want to lend it, you want to put it into real estate deals. If you just want to ask your mom for 10 grand to go do a deal, or another family member, can you legally do that, or are you violating securities law? And Michelle goes really deep into it. She does all of our securities work for all of our private placements and fund documents. And, every time I talk to her, I am always learning something new because the laws are always changing. I know, Jason, your business model is a little bit different, but you still got to deal with some of these securities laws at hand,
We all do. And I just realized that I didn't even have my mic on for the last 2 minutes of talking. Luckily, you were doing the majority of the talking, but hopefully, I guess you could hear me, right? Were you able to hear me earlier?
I could hear you. Otherwise, I would have said something. But that's why we're the number one real estate podcast in the world, because we're real people doing real deals. And with that being said, I think we should just cut over to Michelle's presentation and check it out. And I think that will be the best for this audience. And you guys give us any feedback. If you have any questions, Michelle will be monitoring the feed. So feel free to pop them in the questions and or the comments, and we will get them answered for you.
Excellent. And if you enjoyed this podcast, make sure to like, subscribe, and more importantly, share it with another real estate investor or aspiring real estate investing friend. Enjoy.
I chair our corporate and securities group at the law firm of Gordon Feinblatt. So I do general corporate work. I do a lot of mergers and acquisitions. I am not a dirt lawyer, but I play with the real estate lawyers. I'm not reviewing title. I'm not reviewing purchase agreements. But I get brought in when someone has a deal and they're bringing investors in. And I was mocked for having a slideshow, but I just wanted to make sure I hit all the points. But this is an open forum. Ask questions at any time. We don't have to stick to this. I just wanted to hit the points I wanted to hit. So
Should be down, I think.
Oh.
Hit the down button. Yep.
Got it. So I get these reactions all the time when I start saying I do real estate. I do securities work in real estate deals, and I always get this look from like Scooby-Doo, like, what are you talking about? I'm buying real estate. I'm not selling stock. What do you mean the securities laws apply? And so, a typical deal, there's a developer, a promoter, a major investor who's doing the project, whether it's a multifamily property, a shopping center, and they are getting bank financing for most of the deal, but then the bank says, well, you got to come to the table with some equity. A lot of times the person's not putting up the equity themselves. They're bringing just kind of their friends into the deal who all want to get involved in the deal. So the promoter is selling the interest in either the LLC that's acquiring the property, or they'll form a wholly owned subsidiary that's buying the property, and they're bringing investors into the holding company. And then there's usually a split, whatever the split is going to be. The investors get some sort of preferred return typically. Then they get their capital back if there's a sale transaction, and then there's a split between the promoter who gets a carried interest and the investors get their percentage in it. But that is a sale of a security. It's an LLC interest or a partnership interest. So as you can see, the Securities Act of 1933, which was passed after the 1929 stock market crash, broadly defines security. There's a lot of things in that definition. What it doesn't include is LLC interests or partnership interests. So that's come out of case law. They're deemed to be an investment contract. And so to determine whether you're selling a security in an LLC or a partnership, it's called an economic realities test. There was a case called SEC versus Howey where they were selling interest in orange groves. And the courts determined that those interests in the orange groves were securities. And the test is whether it's a type of investment of money in a common enterprise with an expectation of profits that are derived primarily from the efforts of others, which is most deals. You bring in passive investors in, they look to get their return, but they're not involved in managing the property, they're not doing anything, they're just giving you money. So those interests are securities and they're subject to the securities laws. Similarly, even tenants in common interests, when you're buying property with a bunch of people that are passive investors, those can also be securities. I've done offerings where people are selling participation interests in loans. So they have a loan, they're acquiring a loan, and then they sell pieces of that loan to investors. That's also a security. Now, general partnership, if you have people that are all going in together to form a company, everyone's actively involved in the property, the management, everyone has a role, everyone has a vote, then that's not considered a security because it's not dependent on the efforts of others. Everyone is involved, and so there are deals where it's just 5 people, they're all going to be involved in the company. You don't necessarily have to worry about the securities laws in those situations, but most of the deals I see in real estate, there's a manager who's running it, and then there's the passive investors. Debt can also be a security. If you're selling a bunch of different promissory notes to investors and giving them a return, it's most likely going to be deemed a security. If it's a short-term loan, less than 9 months, I believe is the standard, or if it's a bank is exempt from the securities laws. Their securities are considered exempt. But typically selling a bunch of promissory notes is also a security, and you need to make sure that you're complying with the securities laws.
I'm assuming the best way to know you're complying is hire a lawyer.
Correct.
We're not going to know all those.
Right, exactly. I mean, that's how I got into this. And it probably started about 10 years ago. Someone asked me to look at a joint venture document, and it was a real estate lawyer. And I just was reviewing it. I was asking questions. Well, what are you giving to these investors coming into your deal? And he's like, what are you talking about? This is real estate. I was like, no, you're selling interest in an LLC that's buying a property. You got to give them disclosures, and there's certain filings you can make. And so, when you're selling a security, the SEC says you either have to register your security, like Apple or Nike, you can go and they do an IPO, but you're not going to do that for a small property acquisition. So it either needs to be registered or exempt. And there's a bunch of different ways that you can be exempt. And you have to look at both the federal securities laws as well as each state securities laws where your investors are. So these are kind of the common misconceptions I hear from people all the time. I'm dealing with friends and family. Why do I care about the securities laws? And I always say friends and family are only so friendly till you lose their money. People think if they're selling to less than 35 people, it's not a security or you don't have to give any disclosures. There's no magic number. A couple states have like de minimis exemptions if you're selling to 1 or 2 investors, but the 35 is not a magic number. That comes in, we'll talk about Regulation D later. There is a 35 in that, but it has nothing to do with how many people you're selling to and whether it's a security or not. People think if I'm selling only to accredited investors, I don't have to do anything. They're all rich people. I don't have to worry about giving them any disclosures. If investors have voting rights, it's not a security. That's what I was getting at before, where it's a passive investment. And sometimes even when the company's primarily managed by a manager, investors do have certain rights. Like if they're going to sell the property, they say a certain percentage of the investors have to agree to that. But that doesn't mean that it's not a passive investment because they have some voting rights. Unless they're all actively involved, it's still going to be a passive investment. And some people think if interest in real estate funds are not a security, and that's not the case either. So then you have to figure out, okay, I'm not doing an IPO. How do I fall into an exemption? 3A11 is when you're only doing offering in one particular state, and there's no filings that the SEC requires. And I'm happy to send this presentation to anyone. If you guys see me taking pictures, I'm happy to send it to anyone. I have cards, and I can give you my cards. Now, the problem with 3A11 and interstate exemption, there's no SEC filing, but then you still need to go and look at each state where your investors reside and figure out how you fall into one of their exemptions. And the states are really a pain to deal with. You probably heard about crowdfunding, Regulation CF, and Regulation A. Those are also ways that you can sell securities that are exempt. But again, either you have to you're either going to have to get the SEC to bless your documents, or you have to go to the states and bless your documents. It's a much more expensive process. There's a rule called Flora A2 of the Securities Act, which is just kind of a broad exemption for sales that aren't a public offering. But there's really no hard, fast definition of what that is. It's just case law. You have sophisticated investors, a limited number. You're not going to generally solicit. You can't advertise your deal. You can't email blast it. You have to make sure there's restrictions on transfer. And they have to give you an investment intent that they're not buying it to then resell it. So in light of 4A2 and there not being a lot of guidance, the SEC enacted what's called Regulation D. And that says if you comply with Regulation D, it's a safe harbor, and you will have been deemed to have complied with 4A2, not a public offering. There's a 504 and a 506. 504, you can raise up to 10 million, and you can sell to non-accredited investors, and we'll get into what's accredited, what's not accredited in a few minutes. But again, 504, you have to then comply with each state's laws. So in 1996, Congress enacted National Securities Markets Improvement Act, which is NSMIA, and they said that any offerings under this Rule 506 are completely, eliminated the state's ability to regulate. All they can ask for is a copy of what you're filing with the SEC, and they can charge you a fee. But they can't. You don't have to worry about what Maryland does and what Virginia and what Tennessee does. You just do a filing, and then you are covered. It totally preempts the state laws.
That was a lot real quick.
Yeah, sure. Sorry. I talk fast. I'm sorry. I was born in New Jersey.
So, the one thing about 10 million, if you're raising under that, it sounds like there's no exemption on the amount of people with money, right?
In 504, there's not a limit on the number of people, and you can bring in non-accredited investors. But like I said, then you have to make sure you're complying with each state's securities laws, which usually requires filing your offering documents with the state, waiting for them to come back and give you comments. So it's not an easy exemption to comply with, and it's expensive from a legal standpoint.
What's a blue sky law?
Blue sky is the state laws. I don't know where that term came from or why they call them blue sky laws, but that's just the state securities laws.
But also, if you're not advertising, like say we build relationships and
Uh-huh.
I want to invest $100 grand in his deal, and I'm coming to him, hey, I got $100 grand, can I use this to partner with you somehow? Is that still?
He's not he's the one who's subject to the securities laws. You're the investor. So he's not soliciting, that's good, but is he giving you the right disclosures so that if the deal goes south, you don't suddenly say, well, you didn't tell me that there were these risks involved in this investment.
But it's a CYA.
Exactly.
That's just handing the disclosures out, or should he get a lawyer involved too?
Well, he has to have a lawyer help do the disclosures that are required, and we can get into that. We'll get into that in a little while. Sorry. Okay. So 506B, I would say probably 95% of all deals I do fall in 506B. 506 allows up to 35 non-accredited investors, but your disclosure requirements are much more extensive than if you're dealing with only accredited. So I would say then of those 95%, 99% are to accredited investors only, because it just makes the offering so much easier and cheaper to do. Now for accredited investors, there's no specific disclosure requirements in Rule 506, but there are anti-fraud provisions that we'll get into. I'll get into that in a little while. There is no maximum offer amount. You can raise it however much you want. You have to have a reasonable belief that the investors are accredited, but you don't have to verify under 506B. So if they check the box and say, I'm accredited because I have more than $1 million in net worth, and you don't have a reason to believe they're not accredited, then you're covered. If you know for a fact someone's not accredited and they check the box and says they are, that doesn't protect you because you knew. Yeah. If that person ends up complaining to a securities commissioner and says I wasn't accredited, and they'll say, well, you checked the box, but you knew they weren't accredited, and it's not going to be a defense.
For the purposes of that, what does accredited actually mean?
Right. I think I'm going to get into that in a second. Oops. I don't know what I just did there. How do I make that bigger? I don't know what I did. I don't know what I hit.
Private lenders with different needs of trust. That really doesn't fall under this, right? They're loaning, let's say you got one lender loaning on one deal,
Yeah, I mean, if you're selling a bunch of different notes, I mean, if you're trying to get a bunch of different lenders into your deal on one deal, that's selling a security because you're selling a bunch of promissory notes. Again, it depends. It's a fact. It's always a facts and circumstances test. Oh, thank you. All right. Well, let's see here. Right. And the other thing is, in addition to the no general solicitation, so you have to be careful when you're doing an event like this and doing a pitch deck, making sure that it doesn't get simulcast to a bunch of people. If if it's being recorded and you're trying to sell your securities, you could suddenly fall into having done general solicitation and then you've blown your exemption. So you really need to be targeted when you're contacting people. You can't do an email blast to say, hey, I've got this deal, call me about it. You need to send, one email at a time, or like a group of 20 people, hey, here's my deal that we talked about earlier today. But you do want to have some sort of substantial relationship. They haven't, yeah, go ahead.
Like if we wanted to raise money, say we've gone to like a mastermind, and maybe they have a person that everybody in that mastermind, but it's just like a form that they have for deals. People who belong to that form are there looking to put money in deals. Does that count as general solicitation if you do like a webinar to that group, if they're all in the mastermind and kind of together?
If you're doing something like that, I would first verify that each of them is accredited, because you don't want to end up having someone not accredited who was in that deal. And it depends on the numbers of people as well, what's general. It's not a hard, fast rule, unfortunately. As with everything with the SEC, nothing is bright line. It's always gray area. So I do have a slide with accredited investor. I just want to see which one it is. Here we go. Right. I mean, that's really what the SEC and the state commissioners are worried about, the widows and orphans. They're looking out for investor protections. They don't want someone who can't afford to be in a deal to be investing. Now, do I think that state securities commissioners get a little over-aggressive in deals where everyone's pretty sophisticated, they know what they're doing, but the deal went south, so they decided to make a complaint? Yes. I think that, they could be a little more flexible with these type of real estate deals in particular, but there are sometimes people are taking money from people who can't afford to invest, and that's what they're worried about. So here's accredited investor. So it's an individual. If you're talking about individuals, it's someone who has $1 million in net worth, and you exclude their personal property and the debt on their personal property. It's someone who made over $200,000 a year for the last 2 years, or $300,000 with their spouse. Anyone who's in management, a manager of the company, a general partner, a board of directors, executive officer, they're all deemed to be accredited investors. The SEC just amended the rule last year, and now if you're a broker, a securities broker, not a real estate broker, or if you're an investment advisor, even if you don't meet the financial requirements, you are considered accredited. If your entities has to have $5 million in assets, and it wasn't formed just to make this investment. It's a trust with over $5 million, and the person who's making the investment decisions is a sophisticated person. If it's a benefit plan like an IRA, then you would look at the individual requirements. Is the person whose IRA it is meet those individual requirements? Or if it's an entity and it doesn't meet the 5 million test, all of the owners have to be accredited. So you can't get around the rule by just forming an entity, having a bunch of people invest in that entity, and then the entity makes the investment. You have to look through to each investor. There's a bunch of others, but these are the main ones that would really apply in these types of deals. So what I was saying, 506C was created in 2013, and that does allow you to advertise your deal. You could blast it to anyone you want, and it can only be to accredited investors. But not only do they have to be accredited, you have to verify. You have to get tax returns, you have to get W-2s, some sort of statement from their investment manager showing, yes, they have $1 million in net worth. And so a lot of investors don't want to do that. They don't want to give you all this stuff. So most deals are still 506B, not 506C. But I will say, if you want to look at crowdstreet.com, that is a real estate site that has all these 506C type offerings. And they have a platform that if you register through them to do your offering, you can, it's called Verify Investor. And the investors can upload their documents to that site, and then they will verify for you, so the investors don't have to give you their information. So I've done 2 deals through CrowdStreet now, And you can also see what some of the documents look like. You just put you create a password, and then you can look at all the deals. You can look at the offering documents there. So it's a good way to get, and they've got everything. They've got hotel deals. They've got, the Renaissance in Baltimore was just acquired a couple of years ago using CrowdStreet. They've got multifamily properties, shopping centers, you name it.
So investors can go on there, show they're accredited, and be like, I want to invest. What do you got?
Yep. Oh, you don't even have to show you're accredited to get a password.
Right, but I meant.
But if you want to invest, they'll start sending you emails like, here's this deal if you're interested. You can watch the webinar. But yeah, in order to invest, you would have to verify that you are accredited.
Right, so we can find deals and accredited
Yep.
investors.
Yep.
So you can advertise, just put the disclaimer in there that only to accredited.
Yes, this is only to accredited investors, and you will have to, verify you are accredited. I have disclaimer language on those types of kind of teaser deals if you want to send something out to make sure that there's interest in your deal. I've done those kind of teaser deals.
Do you think, is there any validity to them changing the accredited investor qualifications? Do you think that's actually go through?
I'm sorry, can you say?
The accredited investors, I know the SEC's trying to change.
They're trying to increase the limits.
Do you think that's going to go through, or do you have any insight on that?
I don't have insight. I sit on the Maryland Securities Committee of the Maryland State Bar, and we've talked about the proposed regs. I think there's been pushback on it, and it sort of depends on who's, what regime is in politics. But we're really hoping they don't, because it's hard enough for people to find investors as it is. I understand it's been probably over 20 years since they've changed the definition. So with inflation, it probably does make sense to increase it. But I'm hoping they don't. They're still proposing some other ways to qualify. I think they've won proposals if you have a certain educational background, if you're an attorney or an accountant. So there are still some proposals that they're considering, but I don't have any insight whether it's going to pass or not, because they are proposed doing a cost of living increase to that threshold. And in a 506C, even if all your investors are in fact accredited, if you didn't take those steps to verify, you blow your exemption. So now in Maryland specifically, there is what's called a local issuer exemption. So if you're either based in Maryland, you're a Maryland entity, or you're a Delaware entity, but you're based in Maryland, and you're raising less than $150,000 in 1 year, and you can have up to 10 non-accrediteds and have less than 50 equity holders at the end of that 12 months, you can rely on this, and then you don't have to do any kind of filing. You don't have to do a Form D filing with the SEC, because you could rely on that Flora A2. But these are really for people that are just starting a company and you've got a couple people coming in. It doesn't really apply to real estate deals, because you're always raising more than $150,000.
I just raised that for one deal.
Yeah.
That number.
Oh, really? So you could have, and that's only in Maryland. Each state has their own
The
quirky.
house is in New York for the investors here.
Okay, well, then you'd
So
qualify.
I look at New York,
But you said the investors here.
investors here.
Yeah, you look where the investors are. Yeah. So this local issuer exemption is as close to a friends and family type deal as you can get when you're bringing in a small number, and then you can bring in a few non-accredited investors. But even if you're bringing non-accredited, you still have to be worried about anti-fraud concerns. So it doesn't matter what you rely on. The Securities Exchange Act has a rule called 10b-5, and that's called the anti-fraud provisions, which basically says that an issuer has to disclose anything that's material, necessary to make any disclosed or omitted information not misleading. So you can't say something or omit to say something that would be really material for an investor to know about in making their investment decision. And so even though there's no disclosure requirements for 506 offerings to accredited investors, we still do a disclosure, because it's belt and suspenders. You're making these disclosures to make sure you don't violate the anti-fraud provision. So, and particularly with risk, so I'll get into what's in a private placement memo. Right. So when you're doing a deal, what we usually do is a private placement memo, PPM, a subscription agreement questionnaire, and then the operating agreement, which is what governs the LLCs, how it talks about the preference and how voting rights and how your distributions are going to be made. So the PPM is disclosing any material information to make an informed investment decision. So you're going to give a summary of the investment. You're investing a minimum of $25,000 for X% in the company. You're, excuse me, you're getting a 6% preferred return. You get your preferred return, you get your capital back, and then there's a split, whatever that split is, 50-50, 80-20. However the deal is going to be structured. You want to give a detailed use of proceeds. So you're saying, okay, well, we're getting X bank financing, we're getting X dollars from you investors. Here's where that money's going. Acquisition of the property, closing costs, any kind of construction that needs to be done. That you would do a detailed use of proceeds. You talk about a summary of the property you are acquiring, some of the terms of the purchase agreement, and what's your business strategy? Are you planning to hold it for a couple of years and then sell? Do you want to, hold it for a long-term investment? You go into a little bit summary of the market area, the demographics of where, particularly if it's, multifamily, or if it's a shopping center, is it near a bunch of housing that can draw people to the center? One of the most important things is the risk factors. You really want to go in and essentially tell everyone why they shouldn't invest in your deal. But that way they can't say, you didn't tell me that there was a risk of this. Particularly in light of COVID, there's lots of risk factors for a shopping center where retail is down. And and you can't really just avoid general risks that would apply to any type of deal.
Are they putting COVID provisions in the PPMs now?
Mhm.
Act of God type stuff?
Yes. Putting those types of things, putting in, actual things, where business was closed because of COVID, and therefore, if they're acquiring a current existing shopping center as opposed to a new development deal. But, rent abatements, rent rolls are down, those types of things.
You suggest that go in the PPM?
We did that.
I'm sure. Really read everything you said.
Thoroughly, yes. We had you covered. And then typically you want to give some kind of biography of who's really running the deal so they know what they're investing in. Can they trust you? What kind of other deals have they done? You'd also put a disclaimer that past performance is not indicative of future performance, but you should give some sort of description of the people that you're trusting your money with. Any type of payments, the management fee, if they're getting any kind of development fee, property management fees, those should be disclosed if they're going to affiliates of the manager. Bad boy disclosures. There is one thing that you would be excluded from relying on 506. It was a new rule that came out in 2013 that if there's certain bad boy provisions so the first thing we do when we do a deal is we send a questionnaire to all of the people that are actively involved in the management. They're all really securities related things. Have you ever been convicted of a securities crime? Have you been convicted of any mail fraud? There are things where I've never had anyone check yes, but if somebody does check yes, if the event happened before 2013, you can still do the offering, but you have to disclose that whatever the event was. If it happened after 2013, that person cannot be involved in the offering at all. They really should.
Now, is that date changing with time, or is that just the set?
That's because that's when the law went into effect. So if the event happened before 2013, September 23rd, I think, then you can do the offering, but you have to disclose. You have to tell people that yes, he was an investment banker and he was barred by the SEC for. I actually was an expert witness in a case recently that actually, it wasn't, I didn't do the offering documents, but the offering documents, the lawyer did not give out that questionnaire. And it turned out one person, there was a violation and it couldn't have been avoided by disclosing it because it happened after 2013. So it was a whole mess. They're still litigating it. You do a summary of the operating agreement so they understand, what they're getting into, what the waterfall is going to be in the capital stack. Again, if they have no voting rights, you tell them that you're not going to have any voting rights, that the manager is going to have rights to indemnification if there's any claims made against them. And then do a summary of certain tax considerations of investing in a LLC partnership. And like I said, if you go on to CrowdStreet, you can see copies of PPMs. There's tons of them. So they're very informational. I was going to bring some, but I just didn't want to have to take out all the clients' names and stuff. So then the other really important piece is what's called the subscription agreement. And that's where you're getting the reps and warranties from your investors. So it's, I hereby subscribe for 5 units for $100,000. And then they're telling you, yes, I've read all these disclosures. Yes, I've had the opportunity to ask questions of the management and I'm satisfied with my questions. Yes, I'm an accredited investor and here's why. And you check the box. Yes, I understand I can lose all my money. This is a risky investment. I've done these types of investments before. And so those are the types of reps and warranties. And then there's an investor questionnaire that backs up the subscription agreement where you actually ask them, what was your salary? How much did you make last year? What is your net worth? What types of investments have you made in the past? And this is really for the protection of the manager, the promoter, to make sure that they cover their bases.
Do you think you could do a subscription agreement without a PPM if you decided you didn't want to do that?
Yes, I say that later. This is all a level of risk assessment. How much risk you're willing to take on. You got 5 really close friends that are coming in and you're not raising a super large amount of money. maybe you don't need to do disclosures, but at a minimum, there should be a subscription agreement where you get all those reps and warranties, or even if you don't use a subscription agreement, the operating agreement should have those reps and warranties at the end. But I prefer the subscription agreement because therefore it says confirming what they are subscribing for. An operating agreement usually just have an exhibit that shows the ownership, but you never have anything with them saying, yes, this is what I wanted to buy. So, I mean, yes. So this is where we get into what can go wrong. You know, the deal goes south, the investor loses their money, or even if the deal didn't go south, the deal's going well, but they can claim like, well, you told me I was going to double my money, and I've only gotten my money back in my return, and you have no document saying that, or saying that you could lose all your money. Then they could make a claim even if the deal's going okay, but it's not what they thought it was going to be, and you didn't provide anything. So then they can make a claim for rescission, meaning they want their money back plus interest, or they file a complaint with the SEC or the state. Most likely the complaints are going to be with the state. The SEC's, they're looking at like the fraud, they're looking at insider trading. They don't necessarily always want to be bothered with some of the smaller state claims, but the state securities commissioners, they look at they'll investigate every claim they get, whether it's valid or not. And then you're spending legal fees trying to respond to them. So the other thing that comes up all the time in real estate deals is finders, and whether they're inadvertently being a broker dealer. So I hear, someone's giving me the terms of the deal, and they say, oh, so-and-so, he's going to get, 5% of the amount we raise because he's based on the amount of investors he brings us, or he's going to get equity in the deal based on the number of investors. All the time it happens. That's violating the securities laws. You need to be a registered broker dealer to get paid, transaction-based compensation in connection with the issuance of securities.
That broker dealer, is that mortgage broker?
No, a securities broker dealer. So, yeah, go ahead.
That question, so if you had somebody if you were working who was doing that for you, like, if you gave them like GP in the deal, they had an official role, like they are investor relations, and they're an official GP.
Yeah, so you're saying if you had someone who's actually involved in the deal and you're paying them that's still an issue, because I don't remember if I said it in 506 deals. One of the things in 506 is that no one other than a broker dealer can be paid any compensation for helping to raise the capital. So if it's somebody that's, even though they're accredited investor because they're one of the managers or they're a general partner, you can't give them compensation just because they're bringing investors in. They can get their carried interest, their 20%, their 30%, whatever they're supposed to get, because they don't get that till investors have gotten paid back. So you can't do that. And the next slide will show you a difference between finders and brokers. But the other...
Can you then find a broker and just run it through that broker?
Yeah, you could. Yeah, but then you pay them. You're going to pay them a commission. But yeah, you can use a broker. Just a lot of times on smaller deals, brokers don't want to get involved in it. They're usually doing $5 million, $10 million capital raises. They may not necessarily want it. So it could be a good, I think, opportunity for someone who wants to become a broker dealer in a real estate type deal. That might be a good opportunity for someone to do. You basically just take an exam with the state. It's I think it's a Series 7. I don't remember which one it is. It is, yeah.
My follow-up question is, as long as you don't pay them for, in other words, if you just gave them like a percent equity in the deal they doesn't get that.
Can't do that either. It's cash or equity. It's whatever. If you're giving them compensation, it doesn't have to be cash. It can be equity. If they're being compensated because they're bringing investors to you, that a broker is basically someone who is engaged in the business of effectuating transactions in securities. If somebody does it one time, probably not a broker. But the SEC does take a hard stance on that if you're giving them straight base percentage of the deal, whether it's stock or cash. Yep.
You may have answered this, but can somebody that's a non-accredited investor be on the GP side in a deal, even if you have all your paperwork in order?
If they're going to be actively involved in the management, then they are accredited. But if they're just going to be...
Yeah, well, I'm thinking about a specific situation. So these two guys, they approached me, it's like, hey, we want to bring you in on this GP because I have a lot more experience than them. Neither one of them are accredited, but I am. Is that going to work, or should I just...
But they're the ones running the GP? I mean, they started it, right?
It would be the three of us.
Right. So again, if it's the three of you and it's the management entity and you all are going to really be involved, they're not passively. Are they putting any money in? They're starting the company, right?
Well, no,
Right. So I mean, they're not investors. They're like kind of the founders. So I think that situation's probably okay. But again, facts and circumstances, yeah, it's a little gray. But they're not, I don't think they would be deemed the investors. They're the ones raising they're going to be the ones raising the capital. Right. Yeah. So, but the issue is, you could say, oh, well, that's just on the broker dealer. They're not registered. They can pay whatever penalties. But in Maryland and most states, they have an agent requirement as well. So usually the broker dealer could be an entity, and then their employees are called agents of the broker dealer. And the Maryland Securities Act exempts from the definition of agent an employee of the company who's not being paid to raise the capital. But there is a statute in Maryland that says it's unlawful for the issuer to engage an unregistered agent. So it's not just on the unregistered broker dealer or on the registered agent. The company's violating the law by hiring someone and paying them. So I mean, that's where it gets really tricky. And Maryland also takes an unpopular position. It's like based on a 1974 release, that if they see that the same person has their name, and usually when you file a Form D, which is when you do a 506 offering, maybe I skipped past that. When you do a 506 offering, within 15 days of your first sale, you file what's called a Form D. And it's not a very comprehensive disclosure. You say how much you're raising, how much you've raised as of the date of filing, how many investors you brought in as of the date of filing. Did you pay any compensation to brokers? You have to name who the primary people are involved, the GP partners. And that's really all you have to list in it. And then you file that with the SEC, and you file a copy of that with each state. And most of that can be done online electronically. Some states still don't use this electronic platform. Where the investors are. And so that's why, when you get your subscription agreements, you want to make sure they tell you where they live, because you got to go back and confirm where you got to do filings. And each state charges a fee. And Maryland charges $100. New York is the most expensive, of course. Like they can charge up to, I think I just did one at $1,200, and they only had one investor in New York. But Florida is the only state I'm aware of that doesn't require a Form D. For some reason, they don't require you to file it, which is nice. So yeah, I mean, you're going to end up paying some filing fees when you do it, depending on how many states you're selling in. California is like $300, Virginia is $250. But so Maryland, they used to do it. I haven't seen it as much during COVID because I think they've just been busy and not in the office. But they would look at Form Ds, and if they saw, Ian Horowitz's name on 3 different Form Ds filed within a 12-month period, they'll suddenly send a letter saying, well, we want you to show why you're not a broker dealer, because you're presumed to be a broker dealer. And so then you just say, well, listen, I'm not getting compensated. I have a carried interest, but I don't get any money until everyone else has gotten their preferred return. They've gotten some capital, then we split. I'm not getting compensated for raising the capital. So I don't think they do it as much, but that release is still on the books. So here's a kind of a comparison. I don't know if you can see that or not. So you can structure things with finders, but I will never say it's going to be surefire. You're not going to be deemed a broker-dealer, but I've done some deals where they enter into a consulting agreement, and they're providing legitimate investor relations services, and you're paying them either hourly or you're paying them a fixed fee, so it's not contingent on how much they raise. So there's risk on both sides. If you're paying them a fixed fee, then if they don't bring what they thought you were going to bring, then you're giving them either more money or more equity than you were planning, or if they bring a lot in, you're still only getting a fixed fee. But that's one way to avoid it being transaction-based compensation. It's still risky, but if you want to do it that way, that's how I've structured some in consulting type arrangements. But they can't assist any purchasers. You can just say, here's an introduction, you deal with it. They can't give any of the offering documents out if you want them to be a finder and not a broker-dealer. They only make the compensation for the introductions, but it's not tied to the amount that they're raising. And a broker, if they're assisting in a transaction, and this really isn't necessarily on real estate as much as like M&A, if somebody is really just a business broker and they're selling, usually they're trying to sell all the assets of a company, and then through negotiations it ends up becoming a stock deal, 100% stock deal, that's not necessarily going to be deemed to be a broker because the transaction just changed. They weren't out selling securities. It just turned out 100% of the company got sold by stock. They can't give any type of advice on whether they think it's a good investment or not. So these are penalties generally with the SEC. They can require rescission, meaning you give the money back plus interest. The SEC can charge up to 3 times the investment amount in penalties that you pay to the SEC. They can issue cease and desist orders, and this is a big one because they could stop you from doing the current deal. They can also keep you from doing other deals. So they can say you can't raise capital in future deals. So that's a big one. And you'd have to disclose any cease and desist in future offerings if it was a limited cease and desist. And so this is in the state of Maryland. Anyone who willfully violates the securities laws, they can be subject to a fee not exceeding $50,000 or imprisonment not exceeding 3 years. I mean, those are really going after people who are fraudulently, yeah.
Obviously, you got to this point, the deal's gotten sideways. But can the SEC also retract the property, like foreclose on the property from you? Or are they just going to assess the penalties and then just do it?
I think they can. I think they can force a liquidation of the property if that's the only way you're going to be able to get money back to the investors, because you've already spent their money.
Right.
You know. So the Maryland, they can do both criminal action, but they can also do civil side. Like I said, they can do a restraining order, a cease and desist, keeping you from raising capital in the future. They can charge civil penalties. They can freeze assets of the individual. They can order, and then an investor can bring a private action against you. You know, a lawsuit for rescission, saying that you defrauded them. So there are real penalties involved if you're not careful. So this is sort of what I got to at the beginning. It's your level of risk assessment, whether how risky you think the deal is. The more you go outside your circle, the larger amount of money you're raising, the riskier it is, the more you really should be doing this type of stuff. And like I said, at a bare minimum, if you don't want to do a subscription agreement, you would put reps and warranties in your operating agreement. And these disclosure documents are protecting you guys, the people that are raising the capital. They can't come back and say, well, you never told me about that. So don't be penny wise and pound foolish. Other questions? One thing I didn't get into that we were talking at the game on Monday night, some people were asking me about funds, and that's a different way to kind of raise capital rather than doing deal by deal. You decide you're going to create a fund, and then you could say, well, I'm just going to invest in multifamily properties, or we're going to invest in anything. We're going to invest in shopping centers or whatever. We're going to tell you what the deal is right beforehand, but you've committed up front. You're going to commit $100,000 total, and then each time there's a deal, they'll make a draw on that. And I mean, the easier thing about the fund is you only do one SEC filing at the beginning. You don't have to keep doing it for each deal, and you're only so you're only giving one offering document. But it is a little more expensive endeavor because it's a much more lengthy disclosure document because it's a riskier document. You're basically putting all your trust in one person who's going to be making all kinds of investment decisions on your behalf. And so if you're going to start a fund, you also have to be careful of the Investment Company Act and the Investment Advisors Act. The Investment Company Act says that any company that is formed for the investment of securities is going to be an investment company, and then you have to register, or there's exemptions. And there is a real estate fund exemption under the Investment Company Act, but you can't have a right of, the investors can't have a right of redemption to fall into that. And you really have to be investing in real estate. I think 20% can be investments in joint ventures, or but you really need to either be taking a majority stake in a deal, or you just have to be buying property. That's a real estate fund. But if you give them a right of redemption, meaning they can force a buyout at any time, then that wouldn't qualify for that exemption. So that's why most real estate funds are called closed-end funds, meaning they have a closing. Open-end funds is why you have a redemption right. You can't keep someone locked in forever. So that's why open-ended funds that don't have a termination date, they don't necessarily have a total amount they're raising in capital, those usually have redemption rights. But so that's why most real estate funds are closed-end funds, because it ends at a certain period, so they know they'll get out at some point. I know.
But especially because I pretty much go into jail at this point.
I hear that a lot when people finally hear about what they're doing.
You bring this soap, big boy. Anyway, sorry.
No, go on.
But like,
might want to delete that from the tape.
Diversity training, not us.
What?
You're going to diversity training next.
I am.
way worse on that tape. But like when you're looking at this, I mean, there's a point in time where it's juice worth the squeeze, and obviously nobody wants to go to jail, nobody wants to get fined. But if it's a smaller deal, right? And I mean, like, where does it make sense to jump through every hoop? Where does it make sense just to have an airtight operating agreement with those disclosures in it?
Yep.
And, I mean, is there a point in time where you're like, and I know it depends kind of.
Yeah, I mean,
I mean, when you're looking at it, is it like, hey, if I only got one guy going in on this deal, he's bringing $1 million.
Right.
And it's one dude as long as, and I know he's accredited.
Is it somebody you know, or is it someone that somebody just introduced to you?
Yeah,
Like,
it's somebody I know, right?
right.
You know, so I got a deal closing on Monday. The guy's giving me $500,000.
Right.
This is a legit scenario.
Right.
Like one guy's giving me $500,000. Part of it's from a self-directed IRA. Part of it's from
Yep.
cash. It's all coming from the same guy. I know him. I know he's accredited.
Right.
He knows a bunch of properties, blah blah blah, whatever. So in that scenario, like, do I jump through every hoop and file with SEC, or do I, like, he's not part of any operating agreement. He gets no equity. He gets no nothing.
Well, what is he getting for his $1 million?
He's just getting debt.
Oh, he's just getting dead.
Just getting debt.
Secured by the property or
Secured
secured
by
by
the
the
property.
entity?
So like in that scenario, like that's what I'm saying.
Right.
In that scenario, I'm raising money from a private person. Like, does that qualify? Or
But is that an expectation of profits? It's a fixed promissory note. It's a fixed interest rate.
fixed promise?
And it's one note. You're not doing a series of notes. I think you're probably okay. I would still get reps and warranties from him.
Right.
You say a series of notes. What if you go back to that person multiple times?
Right.
The same entity, or we're all different entities though?
Person.
No, but different entity, like
Yeah,
it's
different
entities is different than one entity that continues to raise capital through different.
Scenarios, I borrowed from this. I probably had, I don't know, a couple $1 million out with this guy right now.
Mm-hmm.
So like in that scenario, like do I like where do you cross the line? Where do you say?
It's a gray line, and it's hard to say.
That's the answer.
I know it's gray.
Could you shed some light on rough cost of what it costs, going full tilt versus kind of being
Right.
what you want to do, like cost-wise?
Right, like you want to throw in the operating agreement, these reps and warranties. I can send you. So I'm happy to send those to you that I would put in there. And like I said, they've had the opportunity to ask you certain questions, and they're making this investment and not planning on selling the note. Because a note again can be a security if they sell it. That would not be very significant at all. And I've had one person also that didn't really want to do. They were doing something in Texas and raising $1 million, and they didn't want to do an offering document, but they wanted me to just do a subscription agreement. And I think I did that and do the SEC filings. I think that was like $1,500 or $2,000 to do that.
Yeah, 'cause I mean, you don't.
What? No, and I mean, a fund is going to be a lot more. I'd say a general, you're buying a shopping center, you're buying a multi-family property deal, you want a private placement memo, you want to do it all right and do the filings. It's probably like $7,500 to $10,000, I would say.
But that's like a big boy deal where you're sharing equity. They're all signing an operating agreement.
Yep. Yeah. Exactly.
In this scenario, this guy.
He's not a member of the company, right? Right. Right.
Do you need to do that $10,000 spend on every deal?
Well, it depends. If you're someone who's doing a lot of multifamily properties and your deals are all the same, it's much easier to go back and we change the facts.
Right.
It's like I have one client who's now on his third deal where he's sold properties in DC. He's doing a 1031 exchange. He's now investing in some apartment complexes in Maryland, and the deal is almost identical, other than the preferred return is a different percentage now. Right. So all I had to do was kind of change the facts of where the property is, but the risk factors don't change, and so then the first one costs more than all the others if they're similar.
Yeah. So basically, once you start offering equity, that's when you really need to step your game up.
Right, because you're selling securities.
You can get away with some disclosures or whatever you use.
Right.
But even then, if it's a small deal amongst people you know,
Again, it's how much risk are you willing to take?
I'll be transparent here. We just did an operating agreement. You know who the one main investor is.
Right.
And that's it. There's only 4 of us in this deal.
Right.
For $1.5 million worth of equity, but it's me, Sly,
Right.
2 other guys, and who the big investor is. And
Right.
that's it. Like,
Right.
so.
Right. No, you told me that. You reached out to me originally, and then you're like, oh, we just decided to do it that way. And I'm like, that's fine.
So in terms of the Jimmy's scenario, even Ian's scenario, if they did a fund, they get the same tax benefit or the same benefit.
What do you mean by tax benefit?
Like if this guy wants just debt, could you pick and choose all the funds, how that works, how it's structured?
I've done funds that are hard money lending funds where they're raising equity to then make loans. I've done funds where they're actually selling notes, and then they take the proceeds of that to make loans. But I don't know if I've done any combination funds where some is debt.
That route, we did A and B.
Oh, all right, but they weren't debt. They were different returns, I thought.
No equity, just a 10%.
Right, it was a
pref.
return, but it wasn't a note.
It wasn't a note.
Yeah.
Class A
Right.
shares were just 10% pref, no equity. Class B shares were 8% with equity pref, and all money comes out the same. How do you say it? And I can't refi the A shares out before the B shares. Everyone comes out
Right.
together as one. The A shares won't dilute the B shares. It's the same as getting debt, just not having to go through recording second position. They're basically just getting.
Right, they're getting a preferred return, and then they get their cap back, but they don't share in anything beyond that. Yeah, and I did a hard money fund similarly, where they got a certain preferred return, got their money back, but then they didn't share at all. The manager got the rest of the profits. Clear as mud, yeah. I know, and it's hard. It's really hard to know what to do because it is so great. It's such a gray area. You know, you want to protect yourself, but you don't necessarily want to, like you said, go through all the hoops when you got one person you know really well. So it's just, you kind of figure out what kind of risk are you willing to take and how well do you know the person.
Right.
Is there the risk, so if you didn't do this, right, like if, let's say you had an issue down the road and somebody, a deal blows up and somebody's not happy with you, can they start, like, the SEC start looking at other deals you've done in the past and, like, kind of rake you over the coals for that, or is it just kind of limited to the one that's
Once Pandora's box is open, they probably will ask you what other level of involvement you've done in securities. And it's probably, again, not going to be the SEC. It would probably be more likely be the state securities commissioner, unless someone's alleging fraud. You know, the SEC likes to get involved when they really think it's fraud. And, you know, you were telling them one thing and it was completely, they were investing in something completely different than what you told them. Yeah. But yeah, I would think they would start asking you other questions about what other securities have you been involved in.
or like a JV that was really a security?
Yeah. I mean, JVs are securities. Again, unless it's two entities coming in together, 50-50, and they're both actively involved in it, then it's not really going to be a security because they're both actively involved.
The key is the active involvement.
Yep.
So going back to the hard money fund,
Uh-huh.
let's say you had $1 million of your own money and you wanted to go out and raise another $1 million to put alongside that.
Mhm.
Is it worth doing a fund at that point?
You better wrap it up.
For a couple
Yeah.
million bucks, or how would you structure that?
That's on the smaller side. I mean, the funds I've done have been more, at least 5 million, I'd say. 30. There was one that was 30 million. Another one, I'm trying to think what the hard money one was. I think that was 15 million. So I mean, to raise $1 million for a fund may not be. It depends on what your plans are for how you want to invest that money. If you already know what you're going to.
How would you do that then if that was your scenario?
But so you think you've got how many different things would you buy for the 2 million?
I wouldn't be buying anything. I'd be loaning it to investors.
Oh, you're right. Sorry, making loans. I'm sorry, I got confused. Yeah. It still seems like I mean, I guess what size of the deal of the loans would you be making? It seems like you'd hit that 2 million pretty
Let's
quickly.
say a couple $100,000 a piece.
Okay.
And you're rotating them.
Yeah.
quickly.
That probably makes sense because otherwise you don't, for loaning, you don't want to continue to keep going out and doing a deal. You could do a small fund. That would probably make the most sense to do it that way.
Is it still in that like $10,000 range to set up the fund document?
It's a little bit more depending on, again, what the facts are. If it's something I've already done previously and I've got a good form, it's going to be less. If it's something new and novel.
Yeah.
All right.
Sure.
Majority of us are doing deals with multiple states. So as far as when it comes to attorneys, like, is there any guidance if you can't do a deal in a state? Like, I have that issue all the time.
Yeah.
I do a deal that I have no experience in all the states. I'm going to end up with whoever name comes out. I'm either happy with them,
Right.
hate them, and the deal gets done.
So yeah, that's how I usually get brought into deals. And under 506B, like I said, that's federally regulated. All the states can ask for is a copy. So I'm not worried about the blue sky laws of each state. So I'm not worried about the unauthorized practice of law in different states. Like I'm licensed in Maryland and Virginia. I'm not licensed anywhere else. So typically in a deal, I'm not going to draft a Tennessee operating agreement. I'm going to have a Tennessee lawyer do the real estate side, but they can bring me in to do all the disclosures. So I've done deals in Tennessee and Florida. I did a shopping center deal in South Carolina recently, but they always get the local counsel to comply with the real estate laws down there, and I just do the securities piece.
One more from Moreno, then.
So, what's your class for rep?
Allegedly. So John.
So this friend of mine, close friend.
Uh-huh.
So let's just say they did some deals, small raises, 200,000 to 400,000, like that, not large raises, but a couple of investors.
Yeah.
But it's pretty much a security. Is it possible to go back and present all that paperwork and say, hey, look, by the way, we just give you all the paperwork. If you choose to, divest, you can get out of the deal and fix it.
If you're worried, you could go back and say, listen, we just discovered we didn't really comply with the securities laws. Here's what we would have given you. I mean, the good thing is, and I think I forgot to mention this, is failure to file the Form D doesn't invalidate your exemption. So I've done Form Ds filing 10 years later, and because then you're perfecting the exemption. I mean, they may come back and say, well, why are you filing late? And usually it's just like the client didn't know that they had anything they should have done. And so it's usually when like a client's getting ready to do due diligence for not on the real estate side, but more if my clients are getting ready to sell in an M&A deal, and I'm doing due diligence. I'm like, well, how did you sell these securities? And like, oh, I don't know, we just issued them. So you can go back and file the Form D. I mean, if there are things if you're worried that there's one investor that might, then you could do that. That's again a risk assessment deal, but you could at least go back and file the Form D and at least maybe reconfirm reps and warranties if you didn't get those before. To say, hey, listen, I don't know if you want to do that. If you think anyone would want to get out, I don't know if you want to open up that door. But if you're worried about it, that would probably be the easiest way. Say, listen, I'm offering to give you your money back if you're not in, but if not, please reconfirm your investment, and then I confirm all these investment reps as well, something like that.
His friend, not him.
What? His friend. That's what I meant. Sorry, your friend. Yes, exactly. Right. Very close friend. Right. I understand. Understood.
Well, thank you, Michelle. It was very informative.
Thank you.
Thanks for tuning in to the Real Estate Reserve podcast. Do us a favor and like, comment, and share our broadcast. It helps the algorithm and helps us spread the word too. Till next time, thank you for tuning in.